Hello friends. Today we are going to discuss about penalty guidelines notified by National Medical Commission under the Registered Medical Practitioners Professional Conduct Regulation 2023. I am Dr. Suresh Badadmat, Professor of Psychiatry, working at National Institute of Mental Health and Neurosciences, Bangalore. In this video, I'll be discussing about penalty guidelines. These guidelines were notified under the National Medical Commission Act 2019. This professional conduct of the Registered Medical Practitioners Regulation was notified on 2nd of August 2023. In this regulation, there are various guidelines have been notified. As you see, the regulations has 44 regulations and 11 guidelines. In this video, I'll be talking about guidelines on penalties for violating various regulations. Let's discuss about this penalty. Many a time, either the State Medical Council or EMRB will be requested by the court, maybe consumer forum, with regard to both civil and criminal cases, including the law enforcement authorities, expect the statutory bodies to examine the case and fix the responsibility on RMP. For example, if there is a criminal case against an RMP with regard to death of a patient, invariably the investigating agencies will request the State Medical Council to give an opinion. Similarly, in civil cases like consumer forum, they may also request the State Medical Council to give an opinion. In such a scenario, the State Medical Council need to assess the case and fix the responsibility on RMP. But however, this guideline has been drafted keeping this in mind. The SMC and EMRB should take the following information into account while fixing responsibility or accountability against an RMP. Let's look into what are those important attributes and also the severity of the accountability, how they are assessed. First and the foremost, one need to understand that the quantum of fees of the hospital or the doctor should not determine the punishment or else the penalty. Please remember, the doctor is charging something around 2,000 rupees for a consultation should not determine the penalty. At the same time, if a doctor is taking only 10 rupees as a consultation fees, should not determine just because doctor is taking only 10 rupees, we will not punish him for ethical violation or else professional conduct violation. That means the fees should not be considered to dictate the punishment, the first. The second important is the context under which the RMP was working should be assessed before quantifying the disciplinary action. That is, the alleged harm caused to the patient in the context of the limitation inherent in the patient's clinical features and treatment setting should be considered. What does that mean? The context is very, very essential, my dear friends. Imagine a doctor is working in a casualty or in an emergency situation or in an emergency setting. In an emergency, if there is a mass casualty, for example, there are two transport buses have collided and there is 40 to 50 patients are brought to the emergency in a given time. During that time, the doctor will not be able to provide services to all of them. And you need to know under what circumstances the doctor is working, what is the setting, what is the patient conditions. That is the contextual assessment is very essential. These two important points need to be considered by the SMC and also by the EMRB. Let's look into deeper with regard to attributability of the RMP's negligence or else error or may not be error. and also how the severity is assessed. There are two important points need to be considered: whether the fault of the doctor is there or not there. If it is not there, it will be clear. If it is there, then what are the other contextual, environmental factors which had played? That is, what are the other factors which has contributed to the negative outcome? First and the foremost, the disease severity, patient conditions, patient's comorbid condition, patient's lifestyle, past medical history, available resources with regard to providing treatment, whether there are adequate human resources, whether adequate medications were available, whether the nurses were there, whether other supporting allied healthcare staff was there, whether the laboratory was functioning or not. All other contextual matter at the time of the causality has to be determined. Further, how fast the progress of illness was occurring, whether there was a complete cooperation of the family and the patient, whether there was a violence from the patient relatives and friends, what was the workload at the time when this incident occurred, number of cases at that time, whether whatever the damages has occurred, whether it is reversible, whether it is an error, whether there is a negligence, whether there was a deliberate, willful causality by the doctor, whether there was a compliance for the advice given by the patient or not, or else by the doctor or not, how compliant the patient was there. Reversibility of the medical condition should be considered before the accountability is fixed. Now, on what are the disciplinary action? The disciplinary action has been divided into 5 levels. It is called as level 1, level 2, level 3, level 4 and level 5 based on the severity. Level 1 is the least and level 5 is the severe. L0 has been considered as exoneration. This level is appropriate when the counsel finds the doctor is not at fault. And he is not only not at fault, and he has followed all the NMC regulation. L1 means reformation. I'll be discussing shortly about that. Level 2 means 1 month suspension of license to practice. L3 means 3 months suspension of practice. L4 means 3 months to 3 years suspension of license to practice. L5 is the severe, lifetime suspension of license to practice. Let's discuss each one of them. L1, as I mentioned, is a reformation. Reformation is in the form of advisory, instruction or warning. Here, it is an advisory by the counsel to be careful in near future, and also they may advise him to display qualification, specialization, super specialization, fees which he is charging on the patient. They may also advise him to attend workshops, symposium, CPDs, and various other training activities. They may also ask him to undergo training in conference and also to be careful in near future. That is level 1. Level 1 is more of warning. Level 2 is 1 month suspension from license to practice. This penalty of L2, that is level 2, 1 month suspension, is awarded even when the role of doctor in causing direct harm was not conclusive, but the doctor was found to have breached any of the code which is mentioned under the Professional Code of Conduct under the NMC Regulation 2023, my dear friend. That means, although the doctor negligence is not proved, but he has violated the NMC Code of Conduct, that is enough. The maximum punishment is 1 month suspension from license to practice. Moving to L3. Here, 3 months suspension. This penalty of L3 may be awarded when the role of the doctor in causing direct harm was conclusively proved and the doctor was found to have breached relevant regulations under the Professional Code of Conduct, my dear friends. The maximum punishment is up to 3 months, my dear friends. Level 4. Level 4 penalty is given from 3 months to 3 years, my dear friends. This penalty may be awarded when the role of the doctor in causing direct harm was conclusive, that is proved, and the doctor was found to have breached relevant regulations and severity of the effect on the patient will be considered. The maximum action of suspension is up to 3 years, my dear friends. So this is level 4. Level 5 is permanent suspension for license to practice. This is the last resort, that is debar, for a member should be given by the SMC or by the MRB. And this should be used as a last resort, my dear friends. This penalty may be awarded only after a detailed inquiry carried out by a expert group constituted under the NMC guidelines and finds that the treating doctor has committed a willful or intentional harm or unlawful prohibited action. That means the motivation of the doctor plays a very crucial role in permanent suspension, my dear friends. Not only that, SMC can award L5, that is permanent suspension, but to award a permanent suspension, it has to be ratified by the EMRB board of the NMC. Further, the penalty guideline also says that RMPs who have been exonerated and those who have completed the penalties under the level 1 should not be barred from receiving good standing certificate if required later in their life. This is very beautifully written. Just because there is an inquiry against a doctor or else L1 warning has been given or advisory has been given, the SMC or EMRB cannot refuse to give good standing certificate to the RMP. These are the very important penalty guidelines which have been notified under the NMC regulations, that is RMP's Professional Conduct Regulation 2023, my dear friends. Thank you very much for giving your valuable time. Stay safe.